SJC-11519 in the matter of Kenneth Wynn III.
Yes, counsel. Let's
Good
proceed.
morning, Mr. Chief Justice, Associate Justices of the Court, Andrew Schwartz and Joshua Pemstein from Foley Hoag, representing the consignor artists. The issue in the case is straightforward. Whether a consignor of fine art under Chapter 104A must transmit a separate written statement of delivery to the consignee to obtain the protections of the statute. We submit that the answer is no. We believe that under Chapter 104A, all that is required to establish a consignment are the delivery and the acceptance of the consigned artwork.
So what's the purpose of the written statement? This requirement shall provide a written statement. What's the purpose, if not to sort of create a record, an evidentiary record, so that this could be, this privilege or this protection could be claimed?
Well, it's clear from the legislative history that the separate written statement requirement in Section 2B was added in the 2006 amendments in the wake of the fiascos that occurred with several prominent art galleries that went under. Haley and Steele was one of them, and Boston Corporate Art was the other. And there's no doubt that one purpose of the 2006 amendments, but by no means the only purpose, was to create a record-keeping mechanism that in the event of a gallery failure would make it easier administratively to track down the owners of the art.
It also protects the artists as well as the creditors, right, of the gallery. It protects them because it's evidence of a consignment that isn't subject to, well, you know, I think all those things over there were mine. We had a deal. I mean, it protects both parties here.
Well, there's no question that under the statute from its inception in 1978, and this is consistent with other state statutes and the common law, that delivery and acceptance was all that was required under this statute, and there's no issue in this case whatsoever about what the intent of the parties were. You can look at that Gallery Pro software that's contained in the appendix here, where the word consignment appears in the debtor's records literally in excess of 2,500 times. This is a business, the dealings between artists and other consignors of fine art and galleries that's typically done on a handshake basis without paperwork to memorialize that there is a consignment in the first instance. And there's no dispute in this case that that's what the parties intended.
Is there any evidence in the legislative history that the legislature was concerned about art theft and that the galleries could be used to fence stolen art? Is that a consideration?
We've seen no such evidence in the legislative history. I do want to emphasize.
I'm sorry, but
Please,
it
Justice
is the case in the I mean, the 2000, is it 2006, is that when this was, the amendment?
That's when the amendments occurred.
That not only put in 2B, but it also added the provisions to 4 and 4A about if the consignee can't find the consignor, at some point in time gets to treat the art as his own. So in other words, the 2B statement protects the consignor from having that happen if the consignor has done it. I mean, in other words, within the amendment, there are changes that reflect its purpose. That's all I'm trying to say.
Yes, and that's correct. And if you take a close look, however, there is not exact symmetry between the information required in the separate statement in 2B and the type of information that's addressed later in the statute.
I realize that.
Section
yeah.
4. But you raise a good point. That's one I would have gotten to eventually. in response to Justice Cordy's question, and that is, there are other provisions in this statute that address the concerns that Justice Cordy has raised. For the benefit of the consignor and the protection of the consignee. And by the way, this is not just in the context of failed galleries. We're somewhat obsessed in this case with the fact that this gallery is in Chapter 7, and Haley and Steele and Boston Corporate Art were similarly meltdowns. But we have to deal with this statute as it applies not just to insolvent galleries, but to solvent ones as well. The vast majority of them are solvent. And the rule that will be established in this case will apply across the board. But with respect to the provisions, Justice Botsford, that you referred to in Section 4 and 4A, the consignor is required, forget about 2B, independent of 2B, to keep current contact information with the consignee gallery, and the failure to do that has potential consequences, and very dire consequences. Not just can the artwork be forfeited after a certain period of time, but so too can the proceeds of art sales. So the concerns, and these also were provisions that were introduced in 2006, so the concerns that Justice Cordy is raising are addressed elsewhere.
Could you explain what the consequences are of the artist not filing the statement?
There are no consequences. And it's not the only provision in this statute that's like that. This statute, by the way, includes the word shall 43 times. If you look at, for example, Section 4, capital A, sub A, and Section 2C, these are provisions that impose obligations on the consignee, using the word shall, just like 2B. 4AC talks about the consignee separately accounting on its books with respect to each consignor. 2C requires the consignee to keep books and records for 4 years. There's no consequences attached to those provisions in the statute. On the other hand, if you look at provisions such as 4, again, capital A, B, and C, there the legislature quite specifically provided for consequences for failure to comply with a statutory directive. Specifically, those provisions in Section 4, capital A, B, and C impose penalties on a consignee who fails to remit sale proceeds or return art to the consignor on a timely basis. So this legislature, when it amended the statute in 2006, very well knew how to impose consequences when it thought they were appropriate. It did it conspicuously in Section 4A, B, and C, but it had no consequences attached to the separate writing requirement.
Could I just, this is a dumb factual question, but if under your view of how the statute should work, when the gallery went into Chapter 7, or filed for Chapter 7, are the artists entitled immediately to the return of their artwork? Or I didn't know whether there were, forget writing, but anyway, there were sort of oral contractual arrangements. Yes, I'm giving you this, I'm consigning this to you for 4 years or something, and if the bankruptcy happened in the middle of that. I just didn't know the timing of this.
The consignors are entitled to the property back at will, and upon the filing of the Chapter 7, while there may have needed to be some procedural steps taken in connection with the trustee, they were entitled to the property back under the statute. It's their property.
Forgetting bankruptcy, could they walk in on any particular day saying, I'm not doing this anymore, please give me my art? Can they do that?
Absent the contractual arrangement to the contrary, yes. There's no evidence of any arrangement to the contrary.
And if you lose here today, what's the practical consequence?
Well, the practical consequences, we're back in the bankruptcy court with an evidentiary proceeding because we'll have to decide whether the UCC applies as the trustee, the Chapter 7 trustee maintains. We say it doesn't because everybody knows that galleries are substantially engaged in the business of selling other people's property. Then we'll have an evidentiary proceeding as to whether this is a common law bailment. And these are all the types of issues that this statute is supposed to avoid. That's why we have Chapter 104A.
It's exactly what it's supposed to avoid, and it just seems to me that, although it doesn't list a penalty, the obvious consequence of not filing this should be that it doesn't get the protection of the statute. Doesn't that just seem obvious on its face?
No, it's far from obvious. In fact, it's incorrect, and let me give you two reasons why. First of all, I want to make one more point about the legislative history, and then I'm going to get right to the language of the statute, which is far more important. But before we lose track of the legislative history, because there have been questions about it, the words "any other language herein" that appear in the notwithstanding clause, those were introduced in 2006 simultaneously with the addition of Section 2B. That in and of itself tells you that the legislature was concerned that when it introduced 2B, it could possibly be construed, Justice Cordy, exactly the way you're construing it, and the legislature provided for that in the clearest possible way by saying, notwithstanding any other language herein. And there are cases that make very clear that there is nothing that is a more definitive statement about what the controlling statutory imperative should be than a notwithstanding clause like that. Here's the further point. This is not stressed sufficiently in the briefs, but I want to emphasize it today. You can scour the language that was added in 2006 to this statute, and you will not find anything other than Section 2B to which the notwithstanding clause, any other language, the component of the notwithstanding clause, possibly could relate. That language has no other sensible application except if it's applied specifically with reference to 2B, which was introduced simultaneously. That's very powerful evidence of legislative intent. And in the Ropes and Gray case, this court made clear that looking at the statute before and after can be very telling, and that's why we've given you the red line comparison.
I'm just sort of curious about a potential background fact, and I'm confessing some ignorance about the bankruptcy statute, but could the trustee in bankruptcy have asked for any returns of paintings or artifacts that had been consigned 3 months before the filing of bankruptcy on grounds that it was a preference? And if the answer is yes, did the trustee do that?
The answer is no. The preference statute very quickly applies to payments to creditors in the 90 days. There were no payments here. That's part of the problem of the case. But these are not creditors in that sense anyway. These are parties who have the first priority ownership interest. Let me focus quickly, though, on the language of the statute, because that's really where this argument should begin and end. The statute says in 2A that notwithstanding any other language anywhere else in the statute, all that you need are delivery and acceptance. Delivery is a defined term. It means exactly what it sounds like, physically transporting the property. That definition, by the way, was also added in 2006, although the statute always said delivery and acceptance. So all you need is physically transporting the work. Acceptance is not defined. There's no question in this case but that the paintings were accepted as consignments. The trustee doesn't contend to the contrary, and nor could she. So what the trustee is arguing to you is that you have to construe the statutory word delivery so it includes the separate written statement. Now, that would be judicially rewriting the statute. The legislature added a definition of delivery at the same time that it added this separate statement requirement. And there's absolutely no reference in that very clear definition to the separate written statement. And by the way, apropos of the statute imposing consequences in certain places and not others, there's nothing in the statute that suggests that the failure to supply a separate written statement somehow negates or defeats the formation of a consignment. If that's what 2B was about, you'd expect to see the statute say so, and it doesn't come remotely close to saying so. The other thing to keep in mind is that this statute, from its inception in 1978 through its amendment in 2006, has always had as its paramount objective protecting consignors, and starting in 2006, I should say artists, and starting in 2006, other consignors of fine art. To construe the separate written statement requirement as defeating the formation, or the absence to supply it, as defeating the formation of a consignment in the first instance would completely gut the entire statute and put many artists, including those from out of state, in a situation where they would have consigned the paintings consistent with industry practice and custom, and we've explained the industry practice and custom in the briefs, as have our...
You have, and what's very interesting is, of course, 2A starts, notwithstanding any custom practice or usage, notwithstanding those things, that the delivery, let me ask you this, if 2B had said a consignor who delivers a work of fine art hereunder shall, with the delivery of the work, furnish a statement, would that make a difference?
Not a material difference.
Okay.
The statute
So
would
it's
have-
not part of the delivery,
That's
it's
right.
separate.
And that's the structure of the statute. And more importantly, Justice Cordy, it's the language of Section 1 which defines delivery.
And consignment.
Absolutely. And it defines
delivery.
consignment. And there's nothing in the definition of consignment any more so than there is in the definition of delivery to suggest that the separate written statement is part of the consignment. That's another defined term that
Mr.
makes
Schwartz,
absolutely no
Your
reference.
time is up.
Thank you so much.
Good morning, Justices. I'm Kathleen Cruikshank, and I represent Deborah Casey, who is the trustee in bankruptcy here. Ms. Casey is here on behalf of approximately $500,000 of unsecured creditors, and approximately half of those creditors are in fact artists who are owed commissions because of paintings that have been sold when they had not been paid for those commissions.
Is it your, putting the statute aside, if you prevail, and so you get to sell, not you, your client sells the art that's at issue here, then is it the case that 50% of the proceeds would go back to the artist or not?
Your Honor, if we get to the point where the trustee is in a position to sell, the bankruptcy court will have made a ruling with respect to the artists, and under the UCC, they would be unsecured creditors if the bankruptcy trustee ruled that they were, that the UCC applied.
Be unsecured creditors for what? For the value of the
They would be
value?
unsecured creditors for the amount of the consignment.
So you have a fire sale and no 50%, basically, right?
But that still says that there was a consignment.
Pardon?
If it's for the value of the consignment, it still says there was a consignment.
Your Honor, yes, but of course, you know, if the fine arts statute doesn't apply, then we get to the UCC, which would treat the consignors differently because they hadn't filed UCC statements to protect themselves against the bankruptcy trustee.
Okay, so let's put aside the bankruptcy issue, okay? Let's assume that I am an artist, which no one would contend I am, and I provide a work of art to a dealer, and I'm foolish enough to not provide a delivery, a statement of delivery. What have I done? What does the art dealer have?
You don't have a fine art consignment with the special protections of the fine art
So
statute.
what is there? What is the law that governs?
The law that governs it would depend then on the testimony of the parties, and it's likely that the trustee believes it's likely that the UCC is the law that governs Article 9 of the UCC.
But it's not clear.
I think it's relatively clear, Your Honor.
Okay, and if the UCC governs, assuming that this is a solvent dealer, what happens when the dealer sells my work of art?
If this is a solvent dealer, then there will be money to pay. You don't
Money to pay
But what do
money
you
to
pay?
pay the artists.
pursuant to what?
Yeah.
Well, assuming that this was a solvent dealer, then presumably oral agreements would hold. But we're usually talking about a world where we don't know what anybody's rights are.
So I'm sorry, so if the oral agreement holds, there's a consignment.
Yes, but not a fine art consignment, Your Honor. This fine art statute grants special statutory trust protections, and the artists say that they're entitled to those regardless of whether they've complied with the mandatory written writing requirement. The artists say that the written statement of delivery isn't actually required by the fine arts statute because there's no mention of a writing in the word consignment.
So if it's a non-fine arts consignment, when you sell it, what do I get?
Then you get the UCC, Your Honor.
Which is, I get the value, I get my percentage that was agreed to.
Well, if you're talking about a bankruptcy,
No, I'm not. I'm speaking
Okay,
about just a
outside of the-
routine, I mean, I'm speaking
I'm
about a routine consignment for a solvent dealer, and what does the dealer have then?
the dealer can honor his oral agreement. He doesn't, I don't think the dealer has an obligation to give the painting back if there's a dispute. It's a handshake culture. Everybody relies on trust against one another. That's,
And
everyone relies on
and
trust.
if I don't
It's
get
a
my,
contract.
if
It's
I
a
don't get my
contract.
money, then what do I do? Then I go to a court and say there's an oral contract
Yes,
pursuant to a consignment.
yes.
And if I then say I want my art back, I don't trust you anymore, I'd like my art back because you haven't done a good job of selling it, do I get it back?
If it's an oral agreement and the artist, the dealer is solvent, I would say yes.
Okay, and so your idea is that the legislature intended that the world you described be the world that I suffer from if I'm foolish enough to not provide a statement of delivery, that I suffer the consequences of this uncertainty.
Your Honor, that's why the fine arts statute was enacted, to add a writing requirement, to get away from the uncertainty of the so-called handshake culture that the artists live in.
Apart from its presence in this new statute, is there legislative history that you think supports that interpretation of its presence?
Is there legislative history that supports the?
Your
the written-
view
the
of
written-
why,
Yes.
of the...
Well, Your Honor, first of all, the legislature is presumed to be aware of existing statutes at the time it creates an amendment. And at the time the amendment was passed, the statutory trust protections of the statute were already in existence. So the amendment had to have had a separate purpose.
Right,
And the
so that
back-
it could
I'm
make
sorry.
records. I mean, there's an explanation that doesn't require your explanation for the amendment.
Well, Your Honor, if you look at the words of the statute, the definition of consignment does not contain the word acceptance, nowhere in the definition. Yet, if you read the statute holistically, it's clear from a reading of subsections 2A and C that acceptance by the gallery owner is an integral part of a 104A consignment. So, in order to read the statutes and the sections together, Section 2C requires that the gallery owner maintain that artist's statement of delivery as an acknowledgement of his acceptance. So 2C points back to subsection 2B, which requires that statement of delivery. So you can read, under the trustee's version of the statute, you can read 2A, B, and C together so that they all make sense and they all constitute the elements of delivery and acceptance that are required under subsection 2A.
Doesn't that really require you to put that word in there? When I don't see it in 2A. It says that this is what happens when you deliver it. That's a consignment.
But, Your Honor, the subsection 2A requires delivery and acceptance. The definition of consignment nowhere discusses delivery. So if you look at 2A and C together, they require that statement of delivery to show that there has been acceptance.
You say there's no, consignment is a delivery of the work. Deliver means physically transporting. That's the second definition. And when you...
Well, under 2A of the statute, consignment is delivery and acceptance, both. And if you read, you can read 2A, B, and C together to provide those three, that delivery and acceptance are put together, those elements, by 2A, B, and C. And therefore, the writing requirement comes into play both as evidence of the delivery and evidence of the acceptance. The trustee, I'm sorry.
No, go ahead.
The trustee's interpretation of the statute it respects two very important canons of statutory interpretation. The first being that you read seemingly contradictory provisions so that they're in harmony, and the second being that you don't interpret a statute in a manner that renders a subsection a nullity. And in this case, the artist's interpretation eviscerates the meaning of subsections 2B and C.
When Justice Gantz was asking you questions about the consignment, and you answered in part by saying it would not be a fine arts consignment, it would be some other kind of a consignment, and then the person would be essentially an unsecured creditor under Article 9. But my question is, that response has provoked a question for me. And my question is, what is it about the Fine Arts Consignment Statute, Chapter 104A, that gives the fine art this higher status? Does it make it a security interest?
The Fine Art Statute creates a statutory trust. So the title never passes to the consignee, and under the UCC, the title does pass. So it holds itself out separately.
And shall not be subject to a claim by the creditors of the
Correct.
consignee.
And I'd like to say in response to that, the artist would like you to assign meaning that to the fact that there are no consequences contained in the statute for the failure to comply with the written writing requirement. But that argument overlooks the fact that there are two statutes in Massachusetts that address the subject matter of consignment. And when you have two statutes that address the same subject matter, they should be read in harmony to effectuate a consistent body of law. For artists placing goods on consignment, the Fine Arts Statute is simply door number 1, and the UCC is door number 2. If you comply with A, B, and C of Section 2, the art fits within door number 1. But if you don't comply, you fit within door number 2. And in fact, in the bankruptcy case of Morgansons Limited on page 33 of the trustee's brief, the bankruptcy court notes then that when you're examining the rights of a consignee under a transaction like this, you would look first to Article 9 of the UCC to see if there's a fit. And if there isn't, you'd look to Article 2 to see if there's a fit. And then if no fit, you'd look to common law. And so what the trustee is saying is if you don't find that this transaction fits under the Fine Arts Statute, it would be up to the bankruptcy court, in this case, to decide whether it fits somewhere else.
Well, your brother had mentioned earlier, I think, that if this didn't work the way he was suggesting it would work, then the bankruptcy court would treat it as a bailment.
Your Honor, we differ about how the bankruptcy court would treat the art. The trustee thinks that the UCC would apply in this situation. So we would have to.
And if it were a bailment, what's the answer?
It's not clear to me, Your Honor.
You spoke about the interpretation of your brother rendering 2B a nullity. What do you say about notwithstanding any other language herein? What is the purpose of that provision?
Well, Your Honor, what I would say is that notwithstanding any other language herein could mean a number of things. But what we know is that since you can read 2A, B, and C together to form the prerequisites to delivery and acceptance, which renders you the 104A super consignment, the notwithstanding language doesn't apply to subsections A, B, and C. In this situation, it could.
So what does it apply to?
It doesn't apply to subsections 2A, B, and C.
What does it apply to then?
Well, it could apply to the rest of the statute. It could apply, herein is an ambiguous word. It could apply to just subsection A, 2A. It could apply to all of Section 2. The statute, when it was enacted, added a number of responsibilities and obligations of gallery owners. And it could mean notwithstanding those, because you don't want the gallery owner's lack of compliance to take away from the artist's rights under the statute. But I think because the language is ambiguous, and the trustee again would contend it doesn't apply to 2B, but because the herein language is ambiguous, you have to look at the legislative history behind the passage of the amendment.
Can I ask you this? Assuming your interpretation prevails, if people, I don't know the facts well enough, but if some of these artists, is it the case that all of the artists that we're talking about consigned their work after the amendments?
Your Honor, I don't believe that is the case.
So, all right. With respect to artists who consigned their works before the amendment, what do you do with them?
Your Honor, I don't know the answer to that. It's very possible that the trustee would look at that and determine that she should turn them over. But it seems to me that the trustee is faced with a terrible dilemma when she receives all this art, because you just can't go handing out to people without having some sure idea that it belongs to someone.
Well, counsel
you
just
have-
said that there are computer records that would indicate which artworks are there by consignment, no?
In this case, there are some computer records, but that's not compliance with the statute. The
Oh, but
artists,
they're business records,
they're-
presumably.
presumably, but the artists are in the best position to know their art.
But isn't that then a risk to the artist? I mean, if your interpretation of the statute is not the one that we are persuaded is the correct interpretation, what then is to happen with the artworks that are consigned when the artists did not provide the statement? They would be at risk of not getting their artwork back.
They absolutely would, Your Honor. And
But that's the risk that they run by not filing the statement, but it's not a risk to anybody else.
well, it puts a burden on the third parties that are forced to deal with the aftermath of a failed gallery that has no records.
They
You know-
get paid for it.
Pardon?
Did the older version of the statute before the amendment that created the writing requirement, did that also describe the consignment as a trust?
Yes.
So what did the writing add? If it's a trust, you don't have the Article 2, Article 9 problem for the bankruptcy court.
That's right. So the writing gives us, as third parties coming into the scene later, evidence of what belongs to who. It helps sort out the mess when a gallery goes under and there are no records to assist.
But you had said in answer to me that one of the things that distinguished the fine arts trust from or fine arts consignment from other consignments is that it creates a trust. But now you're telling me that the trust existed even under the old version of the statute.
And it didn't work, Your Honor. That's the problem. Then we had the failure of two galleries. A mess was created, and a massive effort was required by third parties at great cost to ascertain what art belonged to who. In a lot of cases, there was no evidence. Sometimes work was missing.
But it's one thing to say it's an evidentiary problem. It's another thing to say that it's a title problem.
I think it's both, because how can you, if you don't have evidence of your ownership, how can anyone hand something to you? You have to have something to show
When you
that.
get up and testify that this was my object, it belonged to me, and the judge believes you, that's a trust relationship. It doesn't become an asset of the bankruptcy estate.
I agree with you that that's a trust relationship. The problem is, what about when it's on a large scale and a bankruptcy trustee is dealing with hundreds of artists and doesn't know what belongs to whom, or the master in Haley and Steele is dealing with potential embezzlements, missing art, incomplete records.
Well, it's got a headache, but it's still a trust.
How can we know? If a reading of 2A, B, and C together logically gives you the conclusion that that written statement of delivery has to provide evidence of delivery and acceptance. Without it, we don't know who anybody's rights are.
I'm going to have to leave it there, counsel. Thank you.
Thank you.